Welcome to the deep dive. Today, our mission is to unpack a brand new legal precedent straight out of the Mexican Supreme Court system. We are looking at Digital Register 23800, which was published exactly today, February 27, 2026. This source sits right at the fascinating intersection of digital rights and access to justice. To start, I want you to imagine you are in a tight spot. You urgently need to file a crucial legal document online, something that could fundamentally impact your life. You manage to get everything submitted, but then a judge throws the entire case out. Not because your case lacked merit, but purely on a...
On a digital technicality. Oh, yeah, that is a universally frustrating scenario.
Yeah.
I mean, we have all fought with clunky government websites before, but when that digital portal stands between you and your constitutional rights, it becomes a much bigger issue.
Okay, let's unpack this, because that exact frustration is the core conflict of the case we are looking at today. A lower court completely rejected an electronic lawsuit. And just for context, this was an indirect amparo, which is basically Mexico's constitutional protection lawsuit. It is a very big deal.
A massive deal. And the reason they rejected it is where the tech headache really begins. The digital file was electronically signed by the authorized legal representative using their official file.
Right. That is the federal judiciary electronic signature.
Exactly. But the actual complainant, the citizen seeking justice, well, they only provided a scanned handwritten signature.
Yeah, they just printed the document, signed it with a pen, and scanned it back in. And the lower court basically said, no official digital signature from the complainant means no case.
Right. But what's fascinating here is how the higher appellate court reacted to that strict dismissal. They reviewed the situation and unanimously reversed the lower court's decision. They ruled that the lawsuit absolutely must be admitted, even without the complainant's cryptographic electronic signature.
But let me play devil's advocate for a second. Isn't the whole point of an electronic signature system to ensure security and prevent fraud? How did the higher court legally justify bypassing that and forcing the system to accept a scanned ink signature?
Well, they went straight to the Constitution to break down the why. They actually looked at Article 1, which establishes a foundational principle of always favoring the broadest possible protection for individuals. Then they coupled that with Article 17, which explicitly guarantees your right to access justice.
So they are essentially saying you cannot just ignore a plea for justice because of a tech formatting issue.
Precisely. The justices argued that legal operators need to act with flexibility. Shutting down a constitutional lawsuit over a missing digital credential directly violates that fundamental right to be heard.
I find the common sense of this ruling really refreshing, especially given the reality of technology. But help me understand something. Why is getting that official digital signature so difficult in the first place? Why didn't the complainant just click a button to sign it?
Because under Article 3 of the Amparo law, getting that file electronic signature is far from a one-click process. It requires navigating a complete maze of bureaucratic requirements. You need your RFC, that is your official tax ID, and your CRP, which is your national registry number. You need to create usernames, passwords, and somehow link it all perfectly within the government portal.
And let's be honest, those portals are rarely user-friendly. Just resetting a password can feel like a full-time job for the average person.
Exactly. And the court explicitly acknowledged that reality. They stated that navigating these complex digital hurdles is simply not common knowledge for the average citizen. It is unreasonable to expect everyone to be an IT expert just to file a lawsuit. Therefore, seeing the scanned, handwritten signature on the document is more than enough to prove the complainant's undeniable will and intent to proceed.
That makes total sense.
Yeah, and if we connect this to the bigger picture, you can see how vital this precedent is. It actively prevents digital illiteracy from becoming a barrier to constitutional justice. It is a perfect synthesis of strict legal principles adapting to real-world technological limitations. The justice system is finally recognizing that the online portal, a tool meant to modernize and facilitate access, cannot inadvertently become a wall that keeps everyday people out.
So what does this all mean? Well, it proves that institutions are actually capable of prioritizing human intent and fundamental rights over rigid technological bureaucracy. In a world where every single service is moving online, it's a powerful reminder that the system must serve the citizen, not the other way around.
I couldn't agree more, which leaves you with an interesting final thought to explore on your own. If high courts are legally recognizing that government digital portals are too complex for everyday citizens, will this spark a mandatory simplification of government technology? Or will the traditional ink signature always remain our ultimate foolproof proof of human intent?